Thank you for joining us this afternoon. Please welcome Chancellor Lauren McKenna.
Welcome, everyone. I'm Lauren McKenna, Chancellor of the Philadelphia Bar Association. As you saw in our opening slideshow, 1971 was the year that Starbucks opened, the year that Amtrak was formed, and the year that President Richard Nixon installed a later infamous tape recording system in the White House. It was a year of protests against the war in Vietnam and in favor of 18-year-olds getting the right to vote. It was also the year that Helen Reddy released I Am Woman, the song which you heard as we entered our program today, which became an iconic theme of female empowerment. We're here today to celebrate another watershed moment of 1971, and that is the 50th anniversary of Pennsylvania's Equal Rights Amendment, which guarantees that legal rights under the law will not be denied on the basis of sex. The addition of this amendment to the state's constitution impacted many areas of life in the Commonwealth for both men and women. It helped pave the way so that last week, exactly 50 years to the day that the ERA was passed, Pennsylvania voters adopted an identical amendment saying that equal rights will not be denied on the basis of race or ethnicity, something that our association has supported. While we're here today to celebrate, we also want to recognize the challenges of the past year during this time of great stress, hardship, and loss for so many. A year ago to the day, George Floyd was murdered in Minneapolis. In addition, within the legal community, we've lost many valued friends and colleagues, including various mentors for many of us. They include Supreme Court Justice Ruth Bader Ginsburg, Lila Roomberg, past Chancellor Doreen Davis, and our dear friend Amber Racine. While we want today to be about a celebration, I think we all need to take a moment of silence now to remember those and anyone who would like to recognize. So we'll just take a moment of silence before we proceed. I want to thank you for taking a moment to remember those who deserve it. And let's consider their legacies as we look forward to a wonderful program this evening. I'd like to thank our organizers who were so caring about how this program was developed and presented today. They include our Women's Rights Committee, the Public Interest Section, and the Women's Law Project. I'd also like to thank our co-sponsor, the Women in the Profession Committee. Now I'm proud to introduce the co-chairs of the Women's Rights Committee, Judy Berkman, and Katayun Jaffari, who will give an overview of tonight's program. Thank you for joining us.
Thank you so much, Chancellor McKenna, and thank you for having this forum to commemorate the 50th anniversary of the passage of the Pennsylvania Equal Rights Amendment. It has really been an honor working with my co-chair, Judy Berkman, and Carol Tracy and Terry Fromson of the Women's Law Project to put together this program for you, the audience, this afternoon. We welcome you to this celebration. As a first-generation American, my parents emigrated from the Middle East to the US before my sister and I were born. My mother sacrificed her home and her family to be in a country where she believed one day her daughters would be treated equally and fairly as women. Thanks to the tireless work of many people, including so many that you will meet and hear from today, my mother's and many mothers' dreams have come true. While we know there is so much more work to be done for equity and equality, today we are here to celebrate and embrace the potential of the future. Okay, we have a star-studded event for you today. We will recognize former state representative Gerald Kaufman, who had the vision to introduce the ERA in Pennsylvania. You will hear from Carol Tracy, Executive Director of the Women's Law Project, who will interview equal rights advocate Eleanor Smeal, former president of the National Organization for Women. Terry Fromson will interview Ann Friedman and Barbara Brown, who graduated from Yale Law School and traveled to Philadelphia in 1974 to advocate for women's rights. You'll also hear a lovely video interview by Lynn Marks of Judge Phyllis Beck regarding her scholarship about the first decades of the PA ERA. That will be followed by an exciting panel moderated by Amal Bass of the Women's Law Project. She'll be speaking with Rita Bernstein, Michelle Hangley, and David Cohen about how the ERA was able to help so many through litigation, including a discussion of the litigation that led to making the male-only Central High School and Girard College co-ed. And finally, we are thrilled to have Julie Sook with us, who will share her thoughts as the author of the recently published We the Women, the Unstoppable Mothers of the Equal Rights Amendment. We're so excited to get started. Thank you all so much for being here. Judy, over to you.
Thanks, Kathy. We've had so much fun planning the celebration of the Pennsylvania Equal Rights Amendment. And those pictures on the slideshow at the beginning brought back so many memories. In 1971, I was in law school in the first class at Boston University, the first class that had 25% women. All the other law schools at the time had about 8% women. And so that was remarkable in and of itself. But I would like to start today, as Kathy mentioned, with the interview that I did with Jerry Kaufman, who was the prime sponsor of the Equal Rights Amendment. He was a close ally of Molly Yard, who in Pittsburgh became later the president of the National Organization for Women. Jerry was a state rep from Pittsburgh at the time and introduced the Equal Rights Amendment in 1969. We're very proud to honor Jerry's leadership in making the Pennsylvania Equal Rights Amendment a reality. But before we start that interview, I just want to acknowledge Patricia G. Miller, whom we were unable to reach. She wrote a 1975 article about the Equal Rights Amendment, and we credit her with some of the facts that are in this interview coming up. Thanks for joining us today.
Great to see you, Judy.
Yeah, when I first met you in the 1980s, I was so excited to hear that you had sponsored the Pennsylvania Equal Rights Amendment, since I had used it in litigation all the way, although unsuccessfully, to the United States Supreme Court.
Did you really?
So yeah, really. So we want to acknowledge and honor you today for your role in making the Pennsylvania Equal Rights Amendment a reality. It's pretty hard to realize that this happened 50 years ago. How did you start working on the Equal Rights Amendment for Pennsylvania?
There were 6 or 7 other women members of the Pennsylvania House, 203 members of the House, and only 6 or 7 were women. I mean, you can just using that piece of data, imagine what the world was like then.
You first introduced the Equal Rights Amendment in November of 1969. There were no hearings. There was no legislative history. In today's world, it seems amazing that Pennsylvania passed the Equal Rights Amendment in both houses in 2 consecutive legislative sessions with no dissenting votes.
That is, when I heard that the last couple of weeks from you, I was amazed. I'd forgotten it.
So what was your strategy with your male colleagues to get the Equal Rights Amendment through the legislature?
My strategy really was not to make a big deal of it. And so what I would say to people is, it's no big deal. So women and men are equal. You know, what are we going to say? The Constitution say women are equal to men, aren't they? Anyhow, why is that a big deal? And as you can see, it passed unanimously twice. Amazing. I'm amazed at myself.
That was great work on your part.
But I didn't do anything. You know what? My strategy was not to do anything.
What was your reaction when it finally passed the legislature the second time?
Well, I was obviously elated. And look what I have done. And ever since then, that's been my great bragging point to when for my legislative career, which was only 6 years. And I always say my big accomplishment was the Equal Rights Amendment.
Well, it certainly was, and you truly are a feminist. And we thank you and honor you for all your work getting this done, even though you said you didn't do anything, you did. And thanks for being the prime sponsor of the Pennsylvania Equal Rights Amendment. And thanks for joining us today to let us.
Thank you for asking me to join you today, because as I said, I'm very proud of that. And I think it accomplished a great deal.
It did. Thanks very much.
That was such a wonderful video. And I too agree with Judy that Jerry, you truly did make a difference and you should be proud. So I see that Carol and Eleanor will be joining us in a moment. Carol, I thank you for joining us. Eleanor, if you would also join us as well, we will get started for the next portion of our program. It really is an honor to introduce the two of you. Carol Tracy will be interviewing Eleanor Smeal. They'll actually be discussing Eleanor's advocacy in 1971 to galvanize support for the passage of the Pennsylvania ERA across the Commonwealth, which she did along with Alma Fox, who is 97, and I should say is still championing women's rights. Carol has been working to advance women's rights for decades. In 1990, she became and currently serves as the executive director of the Women's Law Project, where she has presided over major legal victories in the areas of reproductive rights, discrimination in employment, education, athletics, and welfare. And just like Carol, Eleanor Smeal needs no introduction. As one of the co-founders of the Feminist Majority Foundation, a former president of the National Organization for Women, and publisher of Ms. Magazine, Eleanor's life and work has been dedicated to the achievement of women's equality and human rights. In more than 40 years as a leader in the United States women's movement, Eleanor has changed the landscape of women's involvement in national life and culture. And you both have truly been an inspiration to me. So thank you for being here. Carol, over to you.
Well, I thank you and thank the Philadelphia Bar Association and the Women's Rights Committee for commemorating this very, very important event. A special thanks to Lauren, Judy, and Kathy. So it is my great honor to introduce my friend and colleague, Eleanor Smeal, who, as you heard, is the president of the Feminist Majority Foundation. Now, I have to tell you, Ellie specifically asked that I cut the intro of her short so more time could be spent discussing the importance of the ERA today. That's typical of Ellie. She is forward-looking in so many ways. And if you don't know her, Google her so that you can learn more about her extraordinary career and her work on behalf of women's equality. Not the least of which is one of my favorites, which was her identification of the gender gap, the difference in the way women and men vote, and popularized its usage in election and polling analyses to enhance women's voting clout. So she, like Jerry Kaufman, played a pivotal role in the Pennsylvania Equal Rights Amendment. So, Ellie, let's start 50 years ago. You just heard Jerry describe how easily the Equal Rights Amendment passed the General Assembly. And we know for a constitutional amendment to be enacted, it then has to go to the electorate. And that's when you came into the picture. So let me back up a little bit and ask you, Ellie, how did you get started in women's rights and social justice back in the day, 50 some years ago?
Well, I was just lucky to be in Pittsburgh, I think, in 1970. And actually, I moved there around 67, 68. I had small kids, too, a boy and a girl. So that was equality. And I wanted to find the women's movement, but I couldn't find it. I had this whole thing of where is it anyway? Because you'd see it on television. And I was doing something for Environmental Pittsburgh, and they wanted me to get something duplicated. So I went over to this house where they said in Shadyside, there was a monolith. That's how you printed things in those days, handbills. Anyway, the woman said that was running it, what's a woman like you doing not working for the women's movement? And I said, well, it's funny thing you asked. I don't know. I can't find it. She said, you just found it. This is now. And it was Joanne Evans Gardner. Joanne and Jerry were spark plugs for the women's movement in Pittsburgh. And they changed my life.
Wow, that's amazing. So, how did you do a get out the vote throughout Pennsylvania? And I think it's really important for so many of our younger listeners today to just remember that 50 years ago, there was no internet, there were no computers, cell phones didn't exist, there was no email, there was no Twitter. This was a statewide campaign. What did you do? How did you make that happen?
Well, I was a trained political scientist. Actually, I was thinking of writing about the women's movement, but when it passed, we thought, well, God, we got to make sure it passes the referendum. We were scared to death. I mean, we weren't confident at all. So we decided to do an old-fashioned organizing thing of having women at as many voting locations as possible, handing out leaflets. Remember, there were no Xerox, there were just monoliths too, and handing out leaflets and making sure that they look at the voter and say, vote for women, vote for women's equality, vote for me, that kind of thing, making it very personal. And we spread out all over the state. And by the way, in those days, I could operate 2 phones at one time and carry on 2 separate calls with the kids in the background. I mean, we were into it. And so we got volunteers everywhere, and we did a study afterwards. And actually, where we had our volunteers, we had an 8% higher vote than when we didn't. I mean, we won, and we won big, but we didn't know we were going to win big. We thought if there's going to be a difference, if it's going to be close, it was going in our direction. And
so, who were your partners? Who else were you working? I mean, it was such an interesting time in our history. Who did you learn from? Who did you work with?
Well, we worked a lot with the NAACP. We worked a lot with, I told you, we came from the environment issue. There was the beginning of the environment movement and as well. But the people we worked with the most was the civil rights groups. And I wish Alma could be here today, but basically it was people that were coming from the commissions on human relations. There was both a Pittsburgh one, and there was a Pennsylvania wide one. The Now chapter in Pittsburgh was the 3rd chapter for Now and in the whole country. We didn't know exactly what we were doing. We figured we just had to do it now, though. We kept saying there's no blueprint for equality. We're going for the whole thing. And basically, it was a lot of things over people's houses. We went to malls or shopping centers, we would say, and handed out leaflets about Now. We were creating a list, and we always got the phone number, always got the address. There was no email, of course. And it was just grassroots organizing.
Wow. So, Ellie, could you take us a little bit to where we are today? Because for your whole life, you left Pennsylvania and moved to the Washington scene as you became president of Pennsylvania Now and currently of the Feminist Majority. You've continued to work on the federal ERA. So could you give us a little run through of how that happened and where we are now,
Well,
because we're pretty positive, I hope.
yeah, well, the spirit really in Pittsburgh, I gotta tell my friends in Pittsburgh, and I hope some of them are on this, are listening. They before I was there, Wilma Scott Heidi formed the chapter, became a national president, and there was Jerry and Joanne, Phyllis Weatherby, a whole group of people, Elma Fox, and what they did is, as they're working on the ERA in Pittsburgh and in Pennsylvania, what they did was help to get it through the Senate. And there was no hearings. We were stuck in the House forever. Martha Griffiths, who was from Michigan, got a discharge petition. In those days, the Democrats were stopping us. Now it's the Republicans. But anyway, basically, they disrupted Birch Bayh's hearing on the 18-year-old vote. And they were outraged that they were going to hear voting on 18-year-old voting, and we didn't have equality. So a group of about 20 women led by Wilma Scott Heidi and Jean Witter, who is, to me, was one of the angels of the Equal Rights Amendment, because she was one of the people who figured out how to get it through the states, and especially Pennsylvania. Anyway, they went to Birch Bayh's hearing and disrupted it. They stood up and said they weren't going to be quiet. They weren't going to do anything until he would schedule a hearing on the Equal Rights Amendment for women. And they were going to throw them out. And marshals were going towards them. And Bayh said, no, I'll meet with the women outside the door. We'll figure it out. And that's really when he promises to hold hearings. So the spirit of Pennsylvania went nationwide.
And was a really good friend. So if you could just tell us briefly, as we're getting to the end of this, where are we now? What do you think is going to happen?
Well, we're in a pivotal place. This is a key time. We now have passed it in all 38 states that are required under the law. The last one to ratify was right here in Virginia. And what happened is, of course, it ratified in 2020. Trump was president, and in essence, they issue a memo from the Office of Legal Counsel under the Barr Attorney General that it was not done right and that it doesn't count because it had met the time limit. Now, we are going to change that time limit. We've changed it before. It just was changed again. We removed the time limit. It's in the preamble, which means the states never voted on that time limit. We believe it's not binding, but we can also believe that if Congress put it in, Congress can take it out. And so basically, we passed it in the House. It is now moved to the Senate to remove the time limit. And we hope that we move the time limit. We hope that the memo that says it counts is also removed under the Biden administration. And we hope that we see it certified by the National Archivist soon.
That's great news. Thanks so much for joining us today, Ellie. You've been such a mainstay in this movement, and we're so glad that you're continuing to do it and that it all started here in Pennsylvania. Thanks again.
Thank you.
Thank you, Carol. Thank you, Carol. And Eleanor, you have made such a remarkable contribution to women's rights and equality. Thank you. We only regret that your colleague, Alma Fox, who is 97, could not join us today. I'm pleased to introduce the next part of our program. My cousin, Terry Fromson, is the managing attorney of the Women's Law Project. Terry is well known for her own high impact litigation advocating for women's rights. Terry will interview two of the founders of the Women's Law Project, Anne Friedman and Barbara Brown. In 1971, Anne Friedman and Barbara Brown co-authored with Gail Falk and Professor Thomas Emerson a foundational Yale Law Journal article on the federal Equal Rights Amendment. Then, in 1974, Anne and Barbara, along with Harriet Katz, moved to Philadelphia to establish the Women's Law Project to advocate for women's rights. They played a significant role in shaping Pennsylvania's Equal Rights Amendment soon after it was adopted. Anne went on to work as a public defender and then to be a law professor at Rutgers Law School at the Camden campus, while Barbara went into private practice and is a senior partner specializing in employment law at Paul Hastings in Washington, D.C. Here is Terry's interview with Anne and Barbara, who will be sharing their reflections on their early work on the Pennsylvania Equal Rights Amendment.
Maybe a good place to start is why you decided to focus on the ERA. What was the social and legal context which led you to the ERA and specifically to the Pennsylvania ERA? Anne, would you like to start?
It's so funny that this question, it seems so obvious to us at the time because the Equal Protection Clause of the 14th Amendment had not been expansively read. And in fact, the campaign for the federal ERA and the state ERAs is part of why the Equal Protection Clause was expanded, but it hadn't happened yet. And so the need for a federal constitutional protection and state level constitutional protection for women's rights seemed urgent, and it was part of a national recognition on the part of women's advocates and advocates for children and families.
We just felt this urgency about getting something foundational and permanent and, solid in the Constitution to guarantee women equal rights and across the board. It didn't have to be piecemeal. It didn't depend on the whims of a state legislature one year or another. It was meant to be that bold statement that we needed.
What was your vision of what you could accomplish through the ERA?
Well, part of it is we want to say that Pennsylvania was really attractive to us because of its state equal rights amendment, because we wanted to be involved in working at the state level to make change as kind of a laboratory for the federal effort. And actually, the Women's Law Project was later involved in a project to review the federal code to get rid of sexist language. So we worked at the state level with state language, and we looked at the federal level. So there were lots of things that were just silly that needed to be changed, that, constantly obstacles for men and women who were acting in ways that were inconsistent with gender stereotypes, but which weren't anything that anybody thought had contemporary value. And then there were lots of much more fundamental issues which were controversial, and we wanted to push that forward. But the having the state ERA in Pennsylvania is probably was a major reason why we, because we were in post-law school, we could have gone a variety of places. And in fact, we had long discussions about the appeals of the mountains of Colorado, or did we want to be in DC, but Pennsylvania won out partly because of the state ERA.
And we're very happy that it did. Barbara, if you want to add anything to that.
Well, not much, except that really, the Pennsylvania state ERA has turned out to be, and of course, during those years, it was in the process of becoming one of the most expansively interpreted of the, dozen or dozen and a half state ERAs that exist. And I don't think we recognized it at the time, but all the different dimensions of a constitutional provision. Is it going to apply only to state action, or will it cover private action or sort of quasi public institutions? What will the standard of review be? Will it reach, as Anne said, even those difficult issues like at that time the draft and bathrooms were, front and center? And, would it encompass disparate impact? Although that theory didn't even have its name and exist then, but the notion that, just sort of the way things are would be challenged whether they were explicitly biased or not. And in any event, so Pennsylvania had already started, but it has gone on to have one of the most expansive ERAs. And that was a great, confluence with our work and our desires.
One of the other things about the state ERA in Pennsylvania was that we were often able to use it to advocate for change and officials would go along. I mean, it would be persuasive, so it wouldn't be necessary to file a lawsuit and get a court hearing. And so it was very efficient in that way. And I think that the Pennsylvania Attorney General's opinion about allowing women to use their birth given names, even if they were married, and that it was a matter of choice, even though the decision was reached under an interpretation of Pennsylvania common law, it was influenced by the ERA. And there was a wonderful moment when a school teacher we knew wanted leave for parenting when he had his first child about to be born. And the Philadelphia School District said, oh no, this is for women only. And we were able to write a lawyer letter for him to the school district saying, by the way, that would be an unconstitutional action on your part, and you might not want to do that. They granted him the leave. And so we had the full year of leave. And that happened in fall of 1975, I think, that we wrote that letter. But it was fun to be able to have that kind of tool when you're engaging in negotiation. I think people often think of laws as something that you enforce in court. And what's really significant about an equal rights commitment is that it can influence the legal culture of a place and can make sense to parties and to judges. One fun instance, in retrospect, was a lawsuit that actually started at Community Legal Services that was initiated by a wonderful activist, Lois Fernandez, who objected to the way that children born out of wedlock were discriminated against in various ways in Pennsylvania law. And we were able to combine a federal and a state claim and bring it in federal court under the Equal Protection Clause, but also to argue the state ERA as a claim. And we had to, because some of the discrimination was carried out by Orphans Court, we had to sue the judges because they were the people who administered the law. And it was really wonderful to have that kind of opportunity to work with Community Legal Services and to work with some, unwed people are mistreated, and children born out of wedlock were mistreated.
The laws were changed right around that time about inheritance, about the right of unwed mother to give children their names, all kinds of, as you said, attorney general opinions and laws were changed. So you won.
We like to think, having the Women's Law Project exist all this time and the state ERA, still be a beacon, that's pretty good to look back on.
Thank you so much for joining us today and for sharing your recollections of 50 years ago. Your work has been amazing, and we appreciate all you've done.
Can I just say, I love that video and interview, and it was just so wonderful to hear from Anne and Barbara, and we are so grateful to Terry for putting it together. It's now my pleasure to introduce another video that I'm sure you will enjoy. Lynn Marks's interview of Judge Phyllis W. Beck regarding her scholarship about the first decades of the Pennsylvania ERA. Lynn is the former executive director of Pennsylvania's Vermont Courts. She has served on the Pennsylvania Interbranch Commission for Gender, Racial, and Ethnic Fairness since its inception. She authored a legal treatise on the privacy rights of survivors of domestic violence and sexual assault for the National Center on Women and Family. She has chaired the boards of the Women's Law Project, as well as Living Beyond Breast Cancer and the National Clearinghouse for the Defense of Battered Women. I love the fact that she teaches a course with Judge Beck entitled Hot Topics in Justice and Law. And while she is the recipient of numerous awards, I will raise in particular that she is the recipient of the Philadelphia Bar Association's Sandra Day O'Connor Award. She has been a champion for us, and for that, I'm grateful.
Welcome, I'm Lynn Marks, and I'm honored today to interview Judge Phyllis W. Beck. I know I speak for the planners and for everybody listening to thank you, Judge Beck, for being here today, and more important, for all the work you've done for equality throughout your career. Judge Beck was the first woman to sit on the Superior Court of Pennsylvania from 1981 to 2006. That's 25 years. Before that, she was the vice dean at the University of Pennsylvania Law School, where she taught and where we met. She has received too many awards to mention, but since this is a Philadelphia Bar Association event, I just want to highlight that she was one of the first to receive the Bar Association's prestigious Justice Brennan Distinguished Jurist Award, as well as the Sandra Day O'Connor Award. And since she left the bench, she has had enormous impact on equality as chair of the Independence Foundation, which, among other things, funds public interest law programs in this region, including the Women's Law Project. But what's most relevant for today's discussion is her scholarship in the area of the impact of the ERA, where she co-authored with Joanne Alfano Baker an article which was in Widener Law School Journal of Public Law in 1994 about the impact of the ERA. Judge Beck, can you tell us how has the Pennsylvania Supreme Court handled the Pennsylvania ERA?
The Pennsylvania Supreme Court had a number of cases before it, starting in the 70s through the 90s. I do think that the ERA is very, very important symbolically, and it is a culture of the state that women should be equal to men. And I guess the courts will catch up with that sooner or later.
So how has the Supreme Court handled the ERA in the family law area?
The Supreme Court has basically equalized the responsibilities and the ownership of the children and property under the ERA. If you go back to the old English law and the early American law, the husband had ownership of the household goods, and he also had a priority in terms of the children. I don't like to use the word ownership, but that's what it was. Well, under the ERA, all of that has been equalized, and the woman now has equal rights in terms of the property and the children.
Can you talk a little bit now about how the executive branch has dealt with the state ERA?
The Attorney General of Pennsylvania is part of the executive of our government. And in 1971, as soon as the ERA passed, the Attorney General made a series of orders. There had been a ban on granting liquor licenses to women. He changed that. It used to be that if a woman was on probation, she could just have a woman probation officer as her officer. He changed that, and he also said women could use their maiden names on legal documents, and that was the beginning when at least the executive was enthusiastic about the ERA. And then in terms of legislative action, in 7 years later, in 1978, the legislature passed an act called the Equalization Act, and it said wherever a gender is mentioned in legislation, it would apply to both genders. And I'll give you an example. The workman's compensation, just by the title workman's compensation, you'd think it applies only to men, but that wasn't true after the Equalization Act. What I think is that there's been a very good cultural shift in the state in terms of recognizing women. And the cultural shift has been led by people like you and Carol Tracy and Judy Berkman. And that's where the important changes have been made in Pennsylvania.
Well, thank you. Much gratitude to you, Judge Beck, for talking today and for all you've done for equality. And of course, thanks to the Philadelphia Bar Association, particularly its Women's Rights Committee and Women in the Profession Committee. And of course, hats off to the Women's Law Project for its stellar work, past, present, and future. Thank you for tuning on.
Hi, everyone. Thanks so much, Judge Beck and Lynn. Those early years of successful litigation and changes by legislation and executive action shaped the way for women's and men's rights in Pennsylvania. As I mentioned in my interview with Jerry Kaufman earlier, I represented a client in the mid to late 1970s in an adoption case using the Pennsylvania Equal Rights Amendment. The ERA had already been interpreted to require that biological father's rights had to be terminated, as well as birth mother's rights. Unfortunately, my client lost all the way up to the United States Supreme Court. Juan's parental rights were terminated for incapacity, even though he was a teen who lived with his mom and had lots of experience taking care of the little ones in his close extended family. The judge terminated his parental rights because he was a high school dropout and on his mom's welfare grant, and because he would always be, and I'm quoting here, a permanent burden on the public's largesse. I've always thought that a young woman of any race, ethnicity would have been treated differently. The next part of our program will be moderated by Amal Bass, Director of Policy and Advocacy at the Women's Law Project. She works in a wide variety of areas, including pregnancy discrimination, employment rights, and domestic and sexual violence. Amal will start with Rita Bernstein, a former attorney at the Women's Law Project, who will discuss the litigation that led to the opening of male-only Central High School and Girard College to women. And Michelle Hangley, shareholder at Hangley, Aronchik, Siegel, Pudlin, and Schiller, will comment on her experiences as one of the first 6 women at Central. Thank you, Amal.
Thank you, Judy, for the introduction. So we're going to start with Rita Bernstein. It's really lovely to have you here today. I want you to start with giving us some of your reflections on your time at the Women's Law Project and your work focused on the Pennsylvania ERA.
I joined the Law Project in the late 70s, and it was truly a dream job for me. It was a heady time for women's rights, and it's wonderful to see so many old friends here today. So the Law Project had a big grant from the Ford Foundation to develop the Pennsylvania ERA, largely, as Ann Friedman said, as a laboratory for what the federal ERA could mean. There was a lot of momentum around the passage of the federal ERA, and we had one of the most progressive, potentially progressive state ERAs. And so we had this, one of the biggest grants we'd had to date at the Law Project to develop litigation which would show what the federal ERA could mean for women. That was sort of our charge. And we were, the Law Project, the staff attorneys there were part of a small group of women of national women's rights lawyers. There was only actually a small group of us across the country. Ruth Bader Ginsburg was a member of that group, and we met regularly to discuss how to accomplish the passage of the federal ERA, and the development of the state ERA. Our state ERA was a big piece of that. There were many exciting and also divisive conversations in that group because we were determined, unsuccessfully as it turned out, to pass the ERA at that time, the federal ERA. And so issues that mattered a great deal to all of us and to which we were all committed, like abortion and gay and lesbian rights, LGBTQ was not even in the lexicon then. The issue was, what do we say about that? And whether the ERA, of course, we hoped that the ERA would promote equality in those areas, but we also were very concerned, or some people in the group were very concerned about what that kind of information, if it got around, would mean for the federal ERA. So the passage seemed very likely, and then there was Phyllis Schlafly, and that's a whole other forum. So one of but the Pennsylvania ERA turned out to be a very valuable tool for women in Pennsylvania, as you've heard. And the law, I and the other members of the Law Project litigated in a number of areas, but I'm going to talk about the education area today. And the first case we brought was against Girard College. And we had a plaintiff, a young girl named Sharon Gray, who was referred to us by her parish in South Philadelphia. And as I think maybe still, certainly when I was in law school, the Girard College case, the race discrimination case, was a very, very big thing that we studied. And Girard College is not a college, as almost everybody knows. It's a free boarding school, K through 12 in Philadelphia, established by the will of Stephen Girard, a big Philadelphia philanthropist, for poor white male orphans. Orphan was pretty quickly defined functionally. It didn't mean you had to be a full orphan. A single parent would qualify you as an orphan. And there was a challenge because of the race. This was a time when civil rights was becoming very, very much believed in, and there was a great reform movement in that area. And here we had this race classification. So there was, you probably remember reading about it, there were thorny civil rights issues and state action issues about the will. And the question was whether the bequest had to fail, because was it his intention, Stephen Girard's, to limit this to white males and white students. And ultimately, the courts decided that the will would be changed and Girard College would be open to poor male orphans in 1968. But the sex restriction persisted. And it was really, Girard was such an important resource for children and families really living on the margin who did not have access to a safe education in their own neighborhoods, and also often just the necessaries of life, food and shelter. And Girard College offered all of that. So we sued under the Pennsylvania ERA, and the Board of Cities Trusts, which administers the funds, really settled very quickly with us. I think they had so much bad publicity in the race case that they did not want to risk that. So that was a huge success. Less of a high-profile case than Central, which I'll discuss next, but really critical for the population that it served. So the Central case. So as people know, or I encounter people now who don't remember that Central was ever all boys, which is just incredible to me. But Central and girls were the top were the most prestigious academic public high schools in Philadelphia. We had sex segregated, academically elite high schools. And it was, we thought, the perfect case. You know how that is, great case, great facts, horrible situation. the perfect case to establish what we were really trying to do under the Pennsylvania ERA, which was have sex recognized as a suspect classification, just as race was under the Equal Protection Clause of the 14th Amendment, which we had not been able to accomplish under the 14th Amendment, and thereby requiring that there would be strict scrutiny of any classification, and any classifications would have to be justified by a compelling reason. That was kind of our goal in the litigation. So we began the Central High case in 83. I know it opened to girls. We may have started it a little earlier than 83. And this was going to be the perfect separate but equal case, or we hoped. And we had every expectation that the two schools, Central High School and Girls High, were equal. Well, as soon as we got into the discovery phase, it turned out that they weren't equal at all. Central had many superior resources. It had a much bigger library. It had many more computers. I think Girls High at that point had 3 computers, which was more than most other public schools had, but Central had many more. Central also had, curiously to us, a private endowment that supported a lot of its programs. So pretty quickly, this was no longer a separate but equal case. But nonetheless, it was fought very, very, very hard by the Central folks. And the alumni in Philadelphia who went to Central are just passionate about Central and about its all boys status. So it was pretty ugly, I have to say. I wouldn't say I got death threats, but I kind of didn't want to go out in public without a bag over my head. I mean, everybody had an opinion about this, and mostly it was not a supportive opinion. But in any event, we prevailed because it was pretty straightforward that they were, even under a much looser standard, it was, unacceptable sex discrimination.
Yeah,
And
we do. Sorry.
Go ahead.
It's wonderful to hear you describe those experiences. And I think that the fact that there are many people you meet now that don't remember that Central was ever a boys' school speaks to how successful that lawsuit was. So thank you for your work on that case. And we have Michelle Hangley here today, who benefited from that case and was a student in the first class of women to go to Central High School. So Michelle, what was your experience like at Central, being one of the first women to walk through those doors?
Well, if I can set the stage, and what made me want to go there was not the library or the endowment or the computers, but I towards Girls High because I expected that I would go there. And the way that Girls was set up was they dismissed 15 minutes later than Central, and their main door was near Central. And after school, the Central boys would come, line up outside the main door, and the girls would kind of come out one or two at a time and sashay down the stairs. And the boys would comment, and then people would meet in clusters, and it was sort of like a dating situation. And I complained to my friend that I was with that this didn't seem like how people should be interacting. And she said, well, you don't have to use that door. And 16-year-old me, full of feminism and hope for the future, thought like that is not how boys and girls, fellow intelligent students should be acting with each other. So I stayed at Masterman, which was then a very, very small co-ed school. I was thrilled when three young women working with the Women's Law Project brought the suit. I watched it with great interest. I never thought it would be resolved before I graduated from high school. But 4 days before I began my senior year, they won. And I don't know, Rita will remember much better exactly what happened, but all I know is that I was in a conference room the night before school started, talking about how we were going to arrive, that we were going to wear comfortable shoes in case we had to run away, and how we were going to deal with this situation. And so we enrolled, and there were 6 of us and 1,000 boys. followed quickly by, I think, about another 20 girls over the next few weeks. The reaction was within the school was very hostile, and outside the school was even more hostile. Within the school, there was a walkout. The boys protested, but at the same time, you know, when you're a Central student, you're a Central student, and there's a certain loyalty, a pack loyalty. So quickly, we were disliked, but also accepted as part of the student body. And by the end of the year, it was not a bad place to be. Outside of the school was another story, especially in the bar and among the judges. The organized bar was very heavily Central grads with a few Girls High grads thrown in. And some people may remember that when the school district decided not to appeal the judgment, the organized or lions of the bar stepped in and tried to appeal it themselves. I thought, and then the judiciary, 75%, I believe, was either Central grad or a Girls High grad. And one of the only exceptions was Judge Maritani, who heard the case, who was not a Philadelphian. And one judge spoke at a Girls High rally to keep the girls out, you know, said terrible things about us. All of the judges made it very clear to anyone who would listen how much they disliked this. It was, as Rita said, it was very uncomfortable being in Philadelphia and being affiliated with this cause in this case. I left, I didn't think I would be coming back after I left Philadelphia after high school. But this particular story has a happy ending, I believe. Things change, people change. People saw what happened to Central, which is that it got better and better and better. And as a co-ed school, it was much stronger than an all-boys school. And eventually I was able to come back here. I went to Penn Law School, and then I was able to practice here. And now I just won my primary to be elected to the Court of Common Pleas, or I believe I'll be the first female Central graduate to sit on that bench, assuming I win in November. So I, it's a test, to me, it's a sign of the power of the courts, the power of the law, and the power of people who have vision to change things, because no one thought at that time that this was a situation that was going to change.
Well, thank you both for being here. Michelle, for sharing your experiences and for being one of the first women to really, to go to Central and to be the start of that path that so many others have followed. And for Rita, for your work on that case and all of the changes that it brought for so many people in Philadelphia. So now we're actually going to go to a documentary video clip. It's excerpts from No Girls Allowed by filmmaker Darlene Cravioto and executive director Victoria Johns. And it's about the experience that Michelle's talking about here. And you'll see Michelle in this video clip. You'll also see a clip of Judge Maritani, who was the trial judge in this case. So here we go.
In 1983, 6 American teenage girls attempted something that hadn't ever been done before. They wanted to go to school, to a public high school in Philadelphia. But there were people who told them no, told them they weren't allowed to go. This is the story of those 6 girls who dared to go anyway.
In the grand scheme of things, I feel that what we did was extremely important for Philadelphia. I can't imagine that at 16, I did what I did.
We were going against the grain, the way that the people of Philadelphia reacted, and even people who weren't involved with Central at all. Pretty much all angry about it. There weren't many people who thought that this was a good thing to do.
The second lawsuit used the Pennsylvania Equal Rights Amendment, which is gives a much stronger standard to laws that discriminate between men and women. Although separate but equal was okay under the federal court precedents, separate but unequal was not okay.
I think Martin Luther King put it very succinctly. He said, injustice anywhere is a threat to justice everywhere. And that is true, if you stop and think about it.
You just can't picture Central being an all-guys school. Like
83, that wasn't really that long ago if you think about it. I was born in the 80s.
Well, the first 6 girls that came here, like we appreciate it so much that we try our best and we try the hardest just to do as well as guys. I mean, like, if you look at our school now, our SA president is a female. A lot of the organizations and clubs are run by females, and it's just like, look at us now.
Look at us now. The clip really does show the impact of the Central High case. And while it wasn't an easy beginning for Michelle and her classmates, who were the first women to go there, look at how much has changed in that time. So, you know, it's great to have David Cohen here to talk about what's happened since the mid-1980s. You know, we've with others in this panel who have talked about what an important tool the PA-ERA has been. And now we're going to talk about what's been happening more recently. So David Cohen teaches constitutional law, reproductive rights, and gender in the law at Drexel University, Thomas R. Klein School of Law. Prior to teaching, David was a staff attorney at the Women's Law Project, and he is currently on the board of the Women's Law Project and the Abortion Care Network. He recently published Obstacle Course, The Everyday Struggle to Get an Abortion in America, co-authored with sociologist Carol Jaffe. So David, let's start with a case called Fisher versus Department of Public Welfare. Can you tell us about that case and recent efforts to address its outcome?
Sure, thanks so much, Amal. So far, we've talked about the successes under the Pennsylvania ERA, but there's been one gaping hole, and that's around abortion and reproductive rights. This comes in the context of what's called the Hyde Amendment. And so to understand Fisher and what's going on now, I'll tell you just a little bit about the Hyde Amendment, which is about abortion payment insurance. So abortion is a pretty inexpensive procedure compared to most medical procedures, but the problem is that about 75% of abortion patients are at 200% of the poverty level or below, which means even though it's a relatively inexpensive procedure, it's very difficult for most people who get abortions to pay for it. So for a lot of people, abortion is covered by health insurance, but for people who are living in poverty, Medicaid does not cover it because of something in the 1970s called the Hyde Amendment. It's an annual budget rider that says that no federal dollars can go towards the payment of abortion, and it's passed every year, and it's to this day. It covers Medicaid, and it also extends to all federal dollars, Medicare, CHIP, federal employees. So this is federal law. So what does this have to do with the Pennsylvania ERA? Well, Medicaid, as most people know, is a joint state and federal program, meaning that there's some federal dollars and some state dollars. And state dollars can pay for something that the federal dollars don't. Currently, there are 17 states that cover abortion under their state Medicaid dollars. 7 do that by legislation. 10 do that because of a court decision from their state courts saying that the prohibition on using state dollars for abortion violates their state constitution. In the 1980s, advocates from the Women's Law Project and several others brought a lawsuit called Fisher versus the Department of Public Welfare, challenging Pennsylvania's version of the Hyde Amendment, saying that the Pennsylvania Hyde Amendment violated the Pennsylvania Constitution. They brought claims under multiple parts of the Pennsylvania Constitution, including the Pennsylvania ERA. The case eventually made it to the Pennsylvania Supreme Court, and in the 1985 decision, Fisher, the Pennsylvania Supreme Court said that there is no claim under the Pennsylvania Constitution for failure to fund abortion through the state Medicaid dollars. The Pennsylvania Supreme Court relied on precedent from the US Supreme Court, saying that the US Supreme Court said that the Hyde Amendment doesn't violate the federal Constitution's Equal Protection Clause, so it doesn't violate the Pennsylvania Constitution's similar clauses. But there was a separate claim brought under the Pennsylvania ERA because, as we know, there is no federal ERA. So the advocates thought that the claim could be brought under the Pennsylvania ERA with all of the wonderful precedent that we've already talked about today. The argument being twofold. One, that pregnancy is the ultimate form of sex discrimination because it is in itself a classification based on sex. And so if all pregnancy care is not covered under Medicaid, that is sex discrimination. And two, that the Hyde Amendment is based on stereotypes that women should be mothers, and sex-based stereotypes are also should also be prohibited under the ERA. The Pennsylvania Supreme Court rejected these arguments, saying that it's not a distinction based on sex, but rather a distinction based on abortion, and that The state can treat women differently based on inherent differences between men and women. And pregnancy is one such inherent difference. The court saying that this condition is so unique as to have no concomitants in the male of the species. Fisher has stood as law in Pennsylvania since 1985, and it has severely limited the ERA, not just around pregnancy and reproductive rights, but anything that can be pointed to as an inherent difference or claimed to be an inherent difference between men and women. In 2019, all of the freestanding abortion clinics in Pennsylvania sued the state once again to overturn Fisher. The lawsuit brought by the Women's Law Project, Troutman Pepper, Planned Parenthood, and I'm also part of this team, basically lays out the harm that the Hyde Amendment causes to abortion clinics and to pregnant people in the state of Pennsylvania, and asks the courts, the Pennsylvania Supreme Court, to overrule Fisher, saying that Fisher was wrong at the time, that it misread precedent, it failed to appreciate the full meaning of the state ERA, and also that we have new information tying the importance of abortion insurance funding to women's equality, that women who are denied funds to get an abortion turn out to be worse off in many different ways, and that harms women's equality. This case, like I said, was filed 2 years ago. It was tied up in the Commonwealth Court for a while because state anti-abortion legislators intervened in the case, and the Commonwealth Court ultimately allowed it. When it finally was argued on the merits last fall, the Commonwealth, to an en banc panel of the Commonwealth Court in March, as we expected, the Commonwealth Court rejected our case because Fisher is precedent from the Pennsylvania Supreme Court, and the Commonwealth Court has to follow that. So now we are appealing the case to the Pennsylvania Supreme Court. We filed those papers about 2 weeks ago, and we have an appeal as of right. So the Pennsylvania Supreme Court will hear this case sometime in the near future. We don't yet have a scheduling order, so we don't know the exact timing, but we encourage everyone to follow along because the Pennsylvania ERA will be back before the Pennsylvania Supreme Court, probably later this year, in a very high profile case combining the ERA and abortion funding. And we hope ultimately to overturn Fisher and to show that the ERA does apply in situations like this.
Thank you, David.
Thank you so much, Amal, David, Rita, and Michelle for your wonderful commentaries. I would also like to highly recommend to the audience to watch the full documentary, No Girls Allowed. It was riveting for me, especially as I recall my fellow classmates graduating from middle school, deciding where to go to high school. It is now my distinct privilege to introduce to you Julie Suk. Julie is a Florence Rogatz Visiting Professor of Law and Senior Research Scholar at Yale Law School, and Professor of Sociology, Political Science, and Liberal Studies at the Graduate Center of the City University of New York. She has authored dozens of articles and publications. Her 2020 book, We the Women, the Unstoppable Mothers of the Equal Rights Amendment. Hope everybody can see me holding up the book. I love it, by the way, and I love the pictures in it, Julie. This book is the first and only book to chronicle and assess the 21st century revival of the Equal Rights Amendment. It explores the ERA's past to guide its future, telling the stories of the women lawyers and lawmakers who shaped the ERA over a century. Julie is a frequent commentator in the media on legal issues affecting women, including the New York Times, the Washington Post, Democracy Now!, Bloomberg Law, and CBS News. We are lucky to have you here today, Julie, to share with us your vision of the future, built on the past that everyone just heard about.
Well, thank you so much. It's such an honor to be here, and I want to thank the Philadelphia Bar Association and Kathy. And it's a special honor as well as a curse to follow such an engaging and carefully curated and brilliant program on the history of the Pennsylvania Equal Rights Amendment. So I would like to talk a little bit to begin about the significance of the Pennsylvania ERA to the long 100-year struggle for the federal Equal Rights Amendment. Pennsylvania was one of the first states to pass an ERA in the 1970s. There were a couple of states, Western states, that had ERAs dating way back to the late 19th century, but many states passed state-level ERAs in the 1970s, born out of the same energy of the second wave women's movement that shaped the drive for a federal Equal Rights Amendment. The federal Equal Rights Amendment, as Eleanor Smeal mentioned, got to the floor of the House in August 1970 because of tremendous efforts against tremendous opposition. Martha Griffiths, a congresswoman from Michigan, had to use a discharge petition just to get it to the floor. And August 1970 was the 50th anniversary of the 19th Amendment, which was then commemorated in August 1970 through a national strike for equality with demonstrations in many cities throughout the country, including in New York and San Francisco. And despite all of this energy, the House did actually adopt the ERA by over 90% of the vote in August of 1970, but the ERA died in the US Senate that year in 1970. There was an implied threat of filibuster, some very loud opponents to the ERA, although the majority of congressmen supported the ERA. Some of the vocal opponents kept debating on and on to make minor changes to the bill, including a 7-year deadline. And eventually they ran out of time. It was never voted on in the Senate. And so it had to come back in 1971 when it did ultimately pass in that next session of Congress in 1971 and 1972. But it's important to situate this. We know that the Pennsylvania ERA was adopted even before the federal ERA was adopted by Congress. And of course, the Pennsylvania ERA has its origins in a legal culture of equality that has close connections to the state of Pennsylvania. The Equal Rights Amendment was itself known as the Lucretia Mott Amendment when it was first introduced in 1923. And as we know, Lucretia Mott is an important figure in Pennsylvania in the history of equality. She was a co-founder of Swarthmore College in 1864 during a time when co-education at the college level was not yet a norm. In 1833, she founded the Philadelphia Female Anti-Slavery Society, and she was an active abolitionist in the state of Pennsylvania. Her Philadelphia home was a stop on the Underground Railroad. And indeed, Lucretia Mott was also engaged in global efforts, both to end slavery and eventually also to promote women's rights. In fact, she attended a World Slavery Convention where she met Elizabeth Cady Stanton, and the two went on to write the Declaration of Sentiments, which was presented at the first Women's Rights Convention in 1848 in Seneca Falls. And the Equal Rights Amendment, which was introduced 75 years later, long after her death, was called by its proponents, including Alice Paul, also graduate of Swarthmore College. Alice Paul called it the Lucretia Mott Amendment because when Lucretia Mott was at Seneca Falls, she had a resolution for securing to women an equal participation with men and in the various trades, professions, and commerce. So long before women even talked about getting the vote, they were also talking about the importance of legal and economic equality for women, equality in participation in public life, which included the vote, but went way beyond the vote. And that's why the ERA was conceptualized and introduced 75 years later on the heels of women's suffrage. Alice Paul, who I think is most known for the ERA, indeed, she worked on the ERA with many women lawyers like Crystal Eastman and Bernita Matthews. They began to work on an ERA right after the 19th Amendment because they knew that in order for women to be equal in society, they would need much more than the vote. And they proposed a constitutional guarantee of equal rights, which would extend to all domains. Originally, the federal ERA was worded, women and men shall have equal rights in the United States and in every place subject to its jurisdiction. And she called it the Lucretia Mott Amendment. Alice Paul called it that because of that resolution at Seneca Falls. And Lucretia Mott had been gone for many decades by the time that the ERA was introduced. And Alice Paul lived almost a century to the age of 92, but she did not see the ERA added to the US Constitution by the time that she died. Alice Paul was one of many women whose stories and philosophies of gender equality I chronicle in We the Women, the Unstoppable Mothers of the Equal Rights Amendment. She was one of the many women who made the meaning of the Equal Rights Amendment over 100 years. And state ERAs, like Pennsylvania's, also contributed to generating new meanings as the conditions of inequality changed in Pennsylvania as well as in American society. In the mid-1970s, as the federal ERA was being ratified by the states, Pennsylvania courts took some bold stances with regard to interpreting the state ERA. One important case was DeFlorito versus DeFlorito, which reversed an old common law doctrine that presumed that marital property belonged to the purchaser, often the husband, the breadwinning man. And it made that presumption on the theory, it changed that presumption rather on the theory that as of 1975, it was well understood that women also contributed to the household and would be disadvantaged by a rule that said that marital property upon divorce could be retained by the person who had paid for it. And it's really important that what that case did in 1975 in construing the Pennsylvania ERA was to consider not only formal exclusions of women from educational institutions or formal sex classifications in the law, but the conditions of what it would mean for women to live as equal citizens. And what that meant was that even laws that were gender neutral, like a presumption that marital property belonged to whoever paid for it, that if it had a disparate impact or a disadvantaging effect on women, that too would be problematic under an equal rights amendment. Equal rights amendments, both at the state level and the way that the proponents framed it at the federal level, involved constitutional changes needed and legal changes needed to correct inequalities women face because of their traditional role. And that traditional role that caused disadvantage and inequality was a role as mothers and homemakers. This is also very important when we think about why the ERA failed in the 1970s and why it's back today in the political hopper. There's a simple explanation for why Pennsylvania got an ERA in 1971, but the federal constitution still does not have one, even though both proposals grew at the same time out of the same movement. Article 5 of the US Constitution requires 2/3 of both houses of Congress and 3/4 of state legislatures to make an amendment. The US Constitution is notoriously one of the most difficult constitutions in the world to amend, and it is more difficult to amend than most state constitutions in the United States, including Pennsylvania's. Pennsylvania follows an amendment rule that is typical in many states, which is that the majority, a simple majority of the state legislature can adopt an amendment, then it adopts it again after an intervening election, and then a referendum goes to the people to ratify, and a majority of the people voting need to vote yes in order to get the amendment. And this is indeed how Pennsylvania got a race equality amendment last week, approved by referendum. And it was an amendment that was introduced and thought to be important symbolically and perhaps needed legally after the George Floyd killing a year ago today. The Equal Rights Amendment on the federal level was adopted by both houses of Congress in 1972. And in reality, if you look at the history, the opposition to the amendment was actually less than 1/3 of Congress. But there were rules and ways of allocating power in both the House and the Senate that led the ERA to be bottled up in the House for decades and required a discharge petition led by Martha Griffiths in 1970 just to get a vote. And when it finally got a vote, of course, over 90% of the House voted to adopt it. Then it died in the Senate, and it died because a few vocal opponents could let debate drag on. And that was the way that the 7-year deadline ended up coming into the amendment when it finally passed. That is, when Martha Griffiths reintroduced the ERA in 1971, this time she included that deadline. And she included that deadline because she wanted to quiet the most vocal, though very small number of men in the Senate who were perhaps willing to filibuster. It was probably not necessary to get the votes for the ERA to have that deadline, but nonetheless, she included it, and that's the version that got passed. It's important to note that right at that moment that the Pennsylvania ERA was getting approved, there had been hearings in the House in March of 1971. Patsy Mink, the first Asian American woman to be elected to Congress in 1964, testified and talked about how the ERA was needed to get rid of laws, not only laws that were overtly discriminatory, but also discriminatory in effect. And indeed, some state Supreme Courts like Pennsylvania's were amenable to this much more expansive understanding of equal rights in construing the state ERA. The House adopted the ERA later that year in October of 1971, again by 90% or over 90% of the vote. And 1 month later, the Supreme Court decided Reed versus Reed, the first case that struck down a sex discriminatory law based on the 14th Amendment. Then the Senate voted on it, but the version adopted in 1972 did include that 7-year deadline on ratification. And initially, a supermajority of the states ratified quickly. We got 30 ratifications by the end of 1973, including Pennsylvania in September 1972, less than a year after after Congress sent it to the states for ratification. But ratification stalled by 1978. There were only 35 states that ratified the federal ERA by then, 3 short of the 38 needed to add it to the Constitution. Congress extended the deadline once by 3 additional years. So the new deadline was 1982, but no additional state ratified the amendment. The ERA stalled for 2 reasons. One is that there was a powerful anti-ERA movement. You can watch a TV miniseries with Cate Blanchett about it, Mrs. America, which will be probably far more entertaining than I can tell you, than anything I can tell you about Phyllis Schlafly's crusade against the ERA, which claimed that the ERA would destroy American motherhood and American families. But it was not all Phyllis Schlafly. It was also our Constitution, which gives veto power to former slaveholding states and makes it possible for minorities in the Senate to obstruct legislation that people want. And we also leave state legislatures, including legislatures like Virginia and Illinois, to make their own rules about how they will deal with a federal constitutional amendment. And the story in Virginia until recently was that very often it just never got out of committee in one house of the state legislature. And in Illinois, the state legislature created a 60% supermajority rule for the ratification of federal amendments, which held the ERA back in Illinois until very recently. So in the last 3 years, the ERA has come back on the political scene. Nevada ratified in 2017, Illinois in 2018, and Virginia in 2020. These 3 states came in 40 years after the deadlines, and these states have litigated, claiming that the deadlines were not legally binding. As Ellie Smeal mentioned earlier, Congress has tried to change the deadline by removing it retroactively just as it extended the deadline in 1978. And the House has voted twice now, last year and this year, to remove the deadline. Ultimately, what's at stake in this debate is not just about whether or not, and I think David Cohen's remarks were very interesting, it's not about whether or not the ERA is really going to have a definitive meaning with regard to specific issues like disparate impact or abortion. What's at stake is that there have been 100 years of women in constitution making, some of the women who litigated that Pennsylvania ERA, and the many, many women lawyers and lawmakers who contributed to the ERA's meaning, talked about the inequality of mothers, talked about the need for women's empowerment. In essence, our founding mothers who have made an amendment and needed to be part of the Constitution in order to legitimize those achievements and legitimize those meanings. That's particularly needed today because the pandemic has brought to new light all of the sources of inequality having to do with women's role as mothers and caregivers. So I'll just end by saying this is also a global phenomenon. Just a few days ago in elections in Chile, the first assembly in the world has been elected to write a brand new constitution for Chile, the first assembly that has gender parity. That was one of the rules of electing this, meaning half of the constitution writers will be women. And what that means, if we have half of the constitution writers as women, is that all of the provisions that go into the Constitution will be shaped by women's perspectives as well as men's. When they reached this point, they did say something that I think we should all remember as we think about women in constitution making and the history and future of the ERA, which is never again without us. Never again without us. We, the women, are part of we, the people. And I think that's why it's so important to understand whether it's 50 years of the Pennsylvania ERA or 100 years that it takes to make the federal ERA. Women are constitution makers, and the significance of the Equal Rights Amendment will always be important.
Julie, that was such a fabulous commentary and such an incredible way to end the story, Never Again Without Us. Thank you so much for your remarks. I do have hope in our future, striving for equity and equality for all. I'm also excited to share with everyone that if you do purchase Julie's book from your favorite bookseller, as I have, she will send you a signed book plate commemorating our celebration. So Julie, thank you for that and being able to navigate the new virtual world. Such a pleasure to have you with us today. It is at this time that I would like to thank all of the speakers, live and taped. Your stories and experiences have taught us so much and inspire us as we move forward for a world that must be more equitable for all. I'm also grateful for the Philadelphia Bar Association, for which I've been affiliated for many, many years. It's an organization that makes a difference in our community. Judy and I are grateful for the tireless efforts of Tracy McCluskey, for without whom we would not have been able to share this celebration with you. Thank you also to Rachel Kipp and Dawn Pettit for all of their work of the Philadelphia Bar. And the production and wonderful videos wouldn't have happened without Corey Clark. So thanks for keeping us on time and in line. Finally, I'd like to thank my co-chair, Judy Berkman, who's taught me so much over the last few months. Judy?
Thank you, Kathy. And thank you to all the speakers and the staff. As Kathy said, celebrating the Pennsylvania Equal Rights Amendment's 50th anniversary has been my dream for decades. And I want to thank everyone watching for their participation today. I'm sure everyone would have wanted to join the conversation and ask questions. It just wasn't possible. However, we want everyone to know that the Women's Rights Committee and the Women in the Profession Committee are planning a future CLE on cutting edge issues of facing women's rights today. And so stay tuned for that. And Lauren, thank you so much for hosting this wonderful Chancellor's Forum. We really appreciate your commitment to women's rights.
Thank you, Judy. All I can say is, wow, what a program. And we want to thank you all for joining us this evening. A really special thanks to the Women's Rights Committee co-chairs, Judy Berkman and Katayun Jaffari, and the Women's Law Project, including Carol Tracy and Terry Fromson, for planning this remarkable program. To those who helped pass the ERA in Pennsylvania and all of those who have worked to expand the rights and opportunities available to women and help pave the way for me and other women leaders in the positions we're in today, I wanted to say thank you. I'm proud to serve as the 10th woman chancellor of our bar association, our proud bar association. And it's very meaningful to me that we were able to celebrate this great anniversary during my term as chancellor. We will carry this forward, and we're proud to do the same for future generations of women. And our association looks forward to presenting future programs on legal issues related to equality. That's been a centerpiece of my year as chancellor, and I know it will be a continued focus even after my year as chancellor. Now I'd like to invite everybody to watch some comments of Judge Beck's experiences before we take another look back at 1971 by watching some of the slideshow that we saw at the beginning. Thank you to all who participated. We had great numbers tonight, and I'm so thrilled that you were with us to celebrate this momentous anniversary with the Philadelphia Bar Association.
So Judge Beck, as the first woman to sit on the Superior Court of Pennsylvania in 86 years after its creation in 1895, did you ever face discrimination in your position there?
Yes, and let me tell you a little story. My second session that was in Philadelphia, and I was on the bench. I was on the left side of the bench, and there were my two male colleagues sitting next to me. And a very prominent lawyer came up to argue, and I won't mention his name. And the first thing he said, I have a motion. And I said, all right, what's the motion? And he said, I want you to recuse. And I said, well, why do you want me to recuse? And he said, this is an equitable distribution case and you can't be fair. So it took me a second to digest that. And then I said to him, well, if you represented the woman, would you ask my two male colleagues to recuse? And he was kind of dumbfounded about that question. And then there was another just amusing incident. The first time I sat in Allegheny County in Pittsburgh, and the court crier was just a very, very lovely guy. And he, since I was the first woman he ever saw in the robing room, he tried very hard to make things comfortable for me. But the one thing he forgot was he forgot to take the men's only sign off the bathroom. And I didn't quite know what to do, but what I did was I took the men only sign off the bathroom. And as I say, I liberated the bathroom in the courtroom in Allegheny County.